Hello everyone, today I will be going over intellectual property laws in Canada. So let's go over an overview of what intellectual property actually is. And to sum it up, it's basically an idea that you own, but not the physical object itself. So if you buy something from the store, it's not like you own that intellectual property. And depending on the type of IP, it'll fall under different types of legal rights, which something can fall under more than one kind. But in general, they will all protect your ownership with exclusive use for a limited time, and it will eventually expire for anyone to use afterwards. Like, for example, in 2024, the first Mickey Mouse short expired and went into the public domain. So in this presentation, I'll be going over the definitions of each type of IP, legal right, some examples of infringement and protection for each, and other relevant laws and terms. To start off, we have copyright, which, as it says, it gives you the right to copy and applies to any original creative work, which is anything written, books, or software code produced, like movies, scripts, or plays, and even music, art, or photos. You don't need to formally register a copyright for it to be protected. You own it as soon as you create it, unlike other IP rights. And as an example here, you can see this Nintendo game, Mario Kart 8. And Nintendo, the company, owns this game's code, the art on this game cover, the music in the game, and the character designs. And a note is that if generally an employer will own the creative works that like employees make by default unless there's an agreement saying otherwise. So the developers can't just leave the company and make their own Mario games if they made a Mario game. Nintendo, the company, still owns it. And also, open source software, despite being open source, it still has copyright. There are a lot of different licensing terms it can fall under in terms of how you allow anyone else to use it and contribute. So there's a pretty good website by GitHub here, choosealicense.com, for reference if you're interested. Next up, we have the trademark, which is more about protecting a business's brand identity. So this falls under names, logos, words, images, sounds, designs, and generally this is more about branding, not function. This is for customers to identify a source of goods and services distinctively at a glance. So you also don't need to register trademarks, but it gives you a better defense in case of any disputes over usage. So this TM symbol is for unregistered and the R symbol is for registered. And it gives you direct evidence you own it, exclusive rights for 10 years, which you can renew, but you still need to be responsible for using the trademark regularly, or it can be argued as abandoned if you haven't used it in like the last 3 years. So for example, Nintendo has this ad saying like there's no such thing as a Nintendo. There's these different Nintendo systems and game titles and magazines, but there's no just Nintendo because they don't want people like using it as a generic term for all video games because you can't trademark something that's generic like the word video game. Moving on to patents, these cover the functionality of an invention, which falls under products, chemical compositions, machines, processes, or improvements to any of these. And they also have to be new, useful, and inventive to be patented. And in terms of registration, it's first come, first serve. Whoever registers first owns it, even if you thought of it first, but you can still improve on existing inventions as mentioned. Um, for example, with software, it kind of depends on if you can patent things because lines of code are not patentable because they aren't really physical like products, but software as a whole, like computer programs, might be patentable because Amazon patented their one-click checkout button, which was originally rejected in Canada but reevaluated because it met the criteria of usefulness and innovation. And so it's not just abstract ideas, but it can be based on the utility and inventiveness of the solution as well. And here we have an image of something you may or may not recognize. It might be more obvious on the next slide, but you can see we have the innards of this object, and these numbers in the patent would describe what each part does and how it interacts, the functionality. On the other hand, industrial designs describe the visual appearance of the product, its design, an ornament, shape, pattern, or configuration. Software-wise, these would be icons, interfaces, layouts, and specifically not the functional aspects that patents describe. These are features that appeal to the eye and stand out, providing a competitive edge. So these also, like patents, these also need to be registered to be protected and claim ownership. And you can see in this example image, which might be more recognizable than the last slide, this is the Nintendo Wii Remote. And comparing with the patent, you can see All this is showing is like the outside appearance of all angles, which is why it's so much more recognizable, because it's showing you the intended design of what it's supposed to look like from the outside instead of what it does. Lastly, we have trade secrets, which don't really have legal rights themselves, but they're basically anything that's a secret, which is not public and has value. Like the most famous example is the Coca-Cola formula. So these can help ensure confidentiality before you register something publicly because, patents have to be original to be registered, yet private before you register them, yet you might want to show other people to get their feedback. Or if you just don't want to go through the time to get a patent, or if you just want to keep some data private, because you can also protect info that doesn't fall under intellectual property. Like, for example, for software, algorithms, machine learning models, even data you collect from your customers. However, trade secrets can only be secret while they stay secret, so if anyone comes up with the same thing, or if it's revealed to the public, they can use it too. So now we've seen the main types of IP, and now let's see how they can be infringed. Infringement means breaking the law, and in terms of IP rights, this means generally taking or copying IP without permission. Generally, owners have to monitor this themselves. This won't be done automatically. And generally, whenever you find infringement, you have to take it to court, and they'll officially decide if infringement has occurred. This takes a long time, and there are large consequences in terms of costs paid. So I'll be going over the details of each type and case studies of Canadian cases and how these are infringed and protected. Copyright infringement is as simple as copyright. It's using someone else's copyrighted property without permission. So there's two types of this: direct. You can be the one copying without permission, like downloading a movie directly. And there's indirect, where you're selling or redistributing something that you know infringes on copyright, even if you weren't the one to copy or remake it yourself, like reselling a knockoff product. Um, to address offline infringement, you can send a cease and desist letter or offer to license it out for a fee. We'll cover online infringement a bit later, but the last resort is going to court, which is pretty long. It's expensive, as mentioned. However, like some uses of copyright can be defendable under fair dealing. So fair dealing is a defense that lets you use copyright material for a fair purpose, and the two main aspects are the purpose and fairness. As we can see in the Copyright Act, Section 29, we have the purposes of research, private study, education, parody, or satire that don't infringe copyright. And we also have a bunch of fair factors like the amount copied, like if it was how much was distributed, if they could use alternatives, if there's a public interest, if it was unpublished, and if it competes with the original work. So just as an example, I've been using a bunch of Nintendo images in this presentation, which is Nintendo's property, but I'm using it for the purpose of education and not competing with their product. So this is a fair dealing. And you may have heard of fair use. This is a US law. Technically, these are different, but they actually are pretty similar. The main difference is just Canada provides a list of purposes while the US doesn't and focuses more on the fair aspect. But in practice, the Supreme Court interprets these purposes flexibly as well. And to note, this only applies to copyright, not the other types of IP. So let's get into our first example of copyright infringement involving the internet with Trader versus CarGurus. These are two very similar businesses, both websites listing a bunch of car sales, and CarGurus was basically scraping a bunch of like different dealer websites for different car listings, and they thought this would be all right. Like thought each dealer owned the copyright. However, Trader offers a service for dealers to take photos with trained photographers and license them out. And this was like kind of a minority, like 5% of listings, but it was still significant because it was like 150,000 photos that Trader had copyright for. And photos do count as an artistic work. Trader has ownership and rights, and they checked if this was under fair dealing, and they're like, no, like purpose technically may be research for users researching car listings, but it wasn't fair. Like they're copying the full photos widely distributed. They could have used alternative photos. These photos were already published by Trader for the dealers, and these were competing with Trader themselves. So ultimately, CarGurus was found to infringe copyright. They didn't really pay as much as they could have, since Trader didn't actually lose any business since it wasn't their website. But they still had to pay $2 per photograph for like $300,000. So it sets a precedent to be aware of for anyone with a presence on the internet. Be careful about what you copy. Before we move on from copyright infringement, I want to cover online copyright infringement specifically, since copyright infringement has really changed with the internet and it's really easy to infringe copyright online just by downloading something. So to address this, Canada has the notice and notice regime. It's like the DMCA in the USA, but with a notice instead of a takedown. So companies can see your IP address, they can complain to your ISP, and the ISP will just pass a notice forward. But the takeaway here is you don't have to respond or do anything about this notice, and not a lot of people know this. But it doesn't mean you did it, first of all. It could be anyone sharing your IP address, and second of all, if you do respond, then they know who you are for sure, and they can sue you. But third of all, you might not even get sued because it's a big hassle to go through legal action, and there haven't been any successful cases in practice. So this is more just a fear mongering or copyright trolling tactic to get money from anyone that'll pay up. Their tactic is like, oh, we're threatening you with big fines and legal action, but you can pay this settlement fee to make it go away. And Parliament had to amend the Copyright Act to say you can't do this, you can't offer to settle or demand payments or personal info. So trademark infringement is like other infringement, using a trademark without permission or being confusingly similar. And as mentioned earlier, you need to be responsible for using your trademark or it can be argued as invalid. And the main perpetrator of this is the knockoffs or fake brands that can damage the reputation. And this can also apply to like people using like your trademark as a domain name. So the example for trademark infringement I have here is the case of Subway versus Budway. They're confusingly similar, but not like an exact copy. They're not pretending to be Subway. If you don't know, Subway is a big sandwich restaurant, while Budway is a niche cannabis store. And the factors the court looked at was the name, Subway and Budway, very similar letters, similar pronunciation. Budway is not a real word; it alludes to Subway. The logo, you can see Subway and Budway both have like half light, half dark, and arrow designs. Budway has a sandwich mascot you can see in the top right. Subway is much more established than Budway. A key factor is that their fields are overlapping, that they both sell snacks, like Subway sells snacks, Budway sells edibles. In contrast, the case of Herbs R Us versus Toys R Us was very similar, cannabis versus company, but they were found to not infringe due to not being in the same field. And they both have retail-sized stores, so in the end, they were found to be infringing, doing damage to their trademark, removing distinction, and blurring their brand image. And basically, this is like showing how parody is not a defense, unlike fair dealing with copyright. And Budway had to pay like $40,000 and lost their trademark. Patent infringement is much like the other infringements. Someone is stealing your invention. It's like copyright. You can have direct infringement or indirect, where you like lead someone else to with instructions to infringe and lead them to do it. And you do need a registered patent to claim infringement. So this patent infringement example is a pretty simple case between two chemical companies. Dow patenting these thin and strong plastic resins, which is a chemical composition, and this was valid from 2006 to 2014. And in that time, Nova basically just made the exact same thing and sold it, produced and sold it out. And so Dow sued them. Nova kept appealing until like the Supreme Court dismissed. So this went on for like many years. But the main takeaway is that Dow got like $645 million for all of Nova's profits before, during, and even after the patent. So the main takeaway is like be careful of products you make if they might infringe on existing patents, and this is why registration is so important to make sure you own something. Like the other types of infringement, industrial design infringement is basically just like making the same product design as someone else. Like patents, you do need a valid registration and demonstration that they infringed. So the industrial design case here is Crocs versus Double Diamond. These are shoe companies. Crocs sued Double Diamonds for infringing their fleece shoe design. Expert testimony found that this was not dysfunctional but ornamental, because remember, industrial designs are about the visuals, the aesthetic, and the judge was like, yeah, this is valid. The fleece provides warmth, but there's also more than one way it could work, so that is protected by the aesthetic. It's a valid design, it's registered, and the infringement test, it looks near identical. You can see the two shoes here. Pretty open and shut case. And the final reward, they got all the revenue from that they made off the shoes and plus interest plus court costs. So again, it's important to register and make sure you aren't stepping on anyone else's registration. In terms of trade secrets, they don't fall under specific IP rights, so there's no formal process to protect them, but you can still take them to court and see if there's a criminal offense for theft, which requires always having commercial value, secrecy, and a maintained effort to be secret. And this protection can last forever if kept confidential, yet be lost if made public immediately. And a trade secret can fall under any category, so I don't have a specific example, but there's lots of leaks in the news for reference. So now I'll go into some more miscellaneous terms. The Canada-US Mexico Agreement is an agreement between these three countries signed in 2018. It sets standards for free trade that covers products as well as IP rights in North America, builds on some international agreements that we'll see in the next slide. And one impact it had is that it extended copyright protection after death of the author from 50 years to 70 years before it goes to the public domain, which matches other countries. The World Intellectual Property Organization, or WIPO, has these internet treaties that Canada ratified or agreed to in 2014, which define the international standards for copyright protection and help to protect Canadian copyrights globally and digitally, so you can get paid if your music is played in other ratified countries. So this helps to modernize copyright to new standards with the internet and global players. Speaking of international standards, what if you want to expand your IP rights out of Canada? How are they protected? Well, it depends on the type. With copyright, most countries will automatically extend protection for anything you make in Canada, but for other types of IP, you'll need to either send separate applications to each country or use a system by a WIPO to apply once and simultaneously to all countries. So it's generally not too difficult these days with the modern standards, and it's something to consider if you want to do business globally, which again, with the internet, is pretty viable. So to conclude, in this presentation, we've seen how IP rights can protect your original ideas in various areas, and as we've seen, there's heavy punishments for being found infringing. And like a lot of law, precedent is being established by court cases all the time, which will affect the future to come. And in some example cases you can see in the citations that have happened recently with the internet. There's teachers selling kids artworks online, or government departments sharing passwords to read the news. And so understanding these laws will be important if you're ever interested in making anything original, which probably applies to most people here as we're CS students that are writing code. So overall, I hope you found this informative, and thanks for watching.